Okay, today we're going to talk about the Second Amendment and race. So, there's been a recurring argument in American political debate that the Second Amendment was only ever for white people. And to some people, this sounds like hyperbole. But to anyone who's ever looked squarely at the historical record, the claim is less a provocation and more a matter of a plain description. The issue isn't the text of the amendment, it's the centuries long pattern of who was actually allowed to bear arms, who was punished for doing so, and who the law was written to empower. So the Second Amendment has always lived two lives, one in theory and one in practice. And in practice, the right to bear arms has never been racially neutral. The separation lies between the letter of the law and its application, and it illustrates the difference between equality and equity. So, equality under the law does not mean an equitable application of the law, which gives rise to inequity. When the Second Amendment was drafted, the United States was a slaveholding republic, where citizenship was explicitly racialized. The militias referenced in the amendment were not abstract civic institutions. In the South, they were the backbone of slave patrols. Historian Carol Anderson argues that the amendment was crafted in part to reassure slaveholding states that these new federal government rules would not interfere with these armed patrols, which were forces designed explicitly to surveil, intimidate, and violently suppress enslaved people. She described the amendment as rooted in fear of Black people, and the historical record supports her. At the same time, many states had laws explicitly prohibiting both enslaved and free Black people from possessing firearms. Harvard Law Review has documented how the very generation that wrote the Second Amendment also wrote and enforced racist gun laws, including statutes that allowed white people to enter Black homes and seize weapons. The right to bear arms was never imagined as a universal right. It was a privilege reserved for those considered full members of the political community, white men. The courts reinforced this racial boundary. In Dred Scott versus Sanford, Chief Justice Roger Taney infamously argued that recognizing Black citizenship would entitle Black Americans to keep and carry arms wherever they went, a prospect he deemed unacceptable. His reasoning makes explicit what lawmakers of the era understood implicitly, that gun rights were a marker of citizenship and citizenship was for white people. Now, the Civil War may have ended slavery, but it did not end the racialized policing of firearms. Southern states quickly enacted black codes that again restricted black gun ownership, part of a broader system designed to reassert white dominance after emancipation. These laws were backed by both state violence and extralegal terror. Armed Black people, whether defending their homes, organizing politically, or simply existing, were treated as threats. Legal scholar Patrick J. Charles notes that even when gun laws were written in race neutral language, their enforcement was anything but. Police, courts, and white vigilantes consistently targeted Black gun owners while ignoring similar behavior by white citizens. The message was unmistakable that the Second Amendment might be universal on paper, but its protections were conditional in practice. This is not ancient history, it reverberates in the present. Contemporary reporting shows that Black gun owners routinely face suspicion, police violence, and legal jeopardy, even when they follow the law to the letter. Carol Anderson began her research into the racial history of the Second Amendment after the killing of Philander Castile, a licensed Black gun owner who calmly informed an officer that he was armed, exactly as gun rights organizers instruct. He was promptly shot anyway. Many Black gun owners describe their rights as conditional. noting that public outrage tends to erupt only when a white gun owner is harmed by law enforcement. The presumption of innocence, the assumption of responsible citizenship, the benefit of doubt, all these remain unevenly distributed. When people say the Second Amendment was only ever for white people, they are not making a literal constitutional claim, obviously. They are naming a pattern of behavior. The Second Amendment was drafted in a society where only white men were considered full citizens. Gun rights were systematically denied to black people for centuries. Courts and lawmakers used race to determine who could be armed, and modern enforcement still reflects these racial disparities. The phrase is a critique of lived reality, not legal theory. It points to the gap between American ideals and American practice, a gap that has persisted from the 18th century to the present. But the uncomfortable truth is that the Second Amendment has never operated as a universal right. It has functioned as a racialized privilege extended generously to some and withheld violently from others. That history is not incidental, it is foundational. And it forces a question that gun rights absolutists rarely confront. What good is a constitutional right if its protections depend on the color of your skin? If the Second Amendment is to mean what its defenders claim, if it is truly a right of the people, not just a subset of the people, then the country must reckon with the fact that it has never been applied that way. The work ahead is not about relitigating the past, but refusing to repeat it. Equal rights require equal enforcement. Anything less is not a right at all, but a hierarchy dressed in constitutional language. Until the United States confronts that reality, the argument with the Second Amendment was only ever for white people will continue to resonate, not only because it's inflammatory, but because it is true to the lived experience of millions of Americans.